Let me start with the discussion on the import of software. This was a case of Infrasoft, Delhi High Court. And I will just state that I will not waste my, I will not take your time explaining the case myself because the expert panel will deal with the subject. And we will have the opportunity to debate, time permitting, with all the participants. So what expert will do, Rohan will do is, he'll explain the case and he'll explain the implication of that case. Rohan, please.
Thank you, Mr. Osa. Good evening to all of you. So, in the context of this particular case, the core issue effectively was that the payments which were made towards software, were they effectively liable to tax as royalty, or could these be considered as not being liable to tax as royalty? The relevant provisions would be the provisions of the Indian Income Tax Act, and given where the parties were situated, also the provisions of the Indo-US DTA. And this is what the court had to consider. The court also had before it a set of judgments which seemed to take two opposing sets of views. So you had Motorola and that line of judgments which took a view that this is not royalty. And then you had a set of judgments from Karnataka, in case of Samsung, Sonata, Synopsys, all judgments of another S, Shailendra Kumar, which took a view that this effectively would amount to a royalty. And the issues as crystallized ultimately came down to two sets of issues. Firstly, was this nature of a transaction one where the transaction in the software could be one where we could say that it was royalty? Second, what was the interaction in terms of the provisions of the DTA versus the domestic law? And both of these issues have been taken on, and both of these issues have been discussed in detail in the 174-odd page judgment which has been passed. Let me just submit effectively what the positions ultimately were, factually as well as legally. In terms of the issue on the DTAA, the view which has been taken, and that's a view which partly has also been taken in Sanofi, but relying on Rio Tinto and relying on Azadi Bachar, the court has effectively said that three situations would effectively arise. You first examine whether a transaction is liable under Indian domestic law. Second, if it is so liable, then you examine the position in terms of the DTA and the domestic law, and whichever one is more beneficial is the one which will effectively apply and prevail. To the extent that there may be any divergence or contradiction between the provision of the DTA and of the domestic law, the DTA alone will prevail. And in any situation where the DTA does not legislate for that situation, then the domestic law will prevail. So very clearly the law is crystallized in this whole controversy of DTA versus domestic law on these four principles, and they've taken the lead from earlier judgments, and in the statement that they've made, I think it's the most articulate statement of how we consider the DTA versus the domestic law. Coming then to the issue of royalties, certain facts in terms of the transaction were relevant and were noticed. The three most important facts that were noticed is that the nature of the right given was non-exclusive and non-transferable. Secondly, the party had no right to effectively either disassemble or decompile or copy or transfer in any form or manner the copyrighted material. It could only exclusively have been used by them. And the third factor which was effectively looked at was the nature of the compensation for what was received. Now, based on these three factors, and after considering the judgments in Samsung, the court effectively came to a view in terms of the law to say, firstly, let's analyze what is the nature of a copyright. A copyright is incorporeal and it is intangible, and it has two sets of rights. One, a right of exploitation, whereby you can give a right or yourself cause copyrighted material to be created, or you could transfer a limited part of your copyright or you could transfer the whole of your copyright. That is your bundle of rights in relation to exploitation. The second set of rights are of protection. Namely, if somebody breaches your copyright, you have a right in law to act against them and prevent them. They say, now let us look at what is the nature of the transaction. Have you transferred over the copyright? Have you transferred over a part of the right of use of copyright? Or have you merely transacted in copyrighted material? Now, given the nature of this particular transaction, the entity who received the material had no right of transference, had no right of a sub-license, it had no nature of a copyright. All it had was access to copyrighted material which could exclusively be used for itself. In those facts, what the High Court has then said is, clearly therefore, there is neither a transfer of copyright nor a transfer of a right to use the copyright. The only transaction is in relation to copyrighted material, and as a result, the income in question cannot be treated as a royalty. Having analyzed it thus, let me step back because I am sure my colleagues will have comments.
The first question which arises, possibly I would like to ask you a question. If suppose the way in which this interpretation is made by the revenue and also Karnataka High Court to say that it is a royalty. Now suppose that sometimes you import life-saving drugs which has a patents. Do you think that even that could be a royalty? Because the way in which some of the interpretations made. So therefore it looks absurd. What I am trying to say, what you have interpreted and you have given analysis of the High Court seems to be, my view is quite right. And therefore there should be some clarity on the subject where there is, which is lacking. Hitesh, would you like to comment?
See, this judgment also does not, possibly before I go on to that comment, this judgment, I believe this is a landmark judgment in one sense because it is 174 pages, it has all the commentary on how treaties should be looked at, what are the relevant provisions, etc. And then rightly gone to the treaty and summed up that this is not taxable. However, I believe the Delhi High Court possibly missed a chance here. The chance was that what about the amendments which have been made in the definition of royalty by the Finance Act 2012 with retrospective effect? And possibly even there, whether there was ground to hold that payment for use of a copyrighted article, even under possibly domestic law, and I'm talking of a non-treaty situation, whether that could be still brought within the ambit of royalty, merely on the basis that there is a single limited use that the person buying the software actually uses to make a backup copy for himself. So I think that question still is open to my mind. That possibly will be adjudicated in some forum or the other because Finance Act 2012 really has widened so many frontiers that, as we shall see in other cases as well, that possibly the chances of litigating there also are not ruled out in the near future.
Mr. Hegde, do you think that if the interpretation which Hitesh is proposing or propagating possibly is an explanation 5 or 6 of the Income Tax Act to Section 9(1), if interpreted, nevertheless Section 90 subsection 2 still continues on the statute?
Right, I think I would agree with that, and I think that has been the approach of the High Court. I think the High Court didn't even bother to discuss, I think, the retrospective amendment, and I think, but I do agree with Hitesh that if they had discussed probably the retrospective amendment, then practically how it would help is that, look, now you have two views, and the latest decision of the High Court in the two views, the one which is favorable to the SSC is normally considered, which is again decision of the Supreme Court in vegetable products, and therefore maybe at the tribunal and at maybe at the appellate authority level, you could then take an argument that the retrospective amendment really doesn't make a difference. So probably if the court order was more speaking and probably if they had dealt with the retrospective amendment, it would have gone a long way in, I think, helping taxpayers taking a kind of a firm view.
Thank you, Nandu. Now let's see what Hitesh has to say on warehouse communication. Verizon communication is one decision which was debated in the morning or yesterday's session a little bit. But this is a decision which has a far-reaching impact. The decision which has not only impact on international transaction, in my opinion, has an impact on the domestic transactions. So what Hitesh has to say? Hitesh, this.
Thank you, DP. So this is Verizon Communication Singapore Madras High Court, which ruled that on the question of whether the payment which was made for an international private lease circuit is taxable in India, is taxable on account of it being a payment for royalty, or it is not taxable in India on account of being a business income. And unfortunately here, very respectfully though, the Madras High Court actually was very much carried away by the retrospective amendments to the section 914, the explanation 5 and explanation 6, which were made retroactive from 1/4/1976, when these sections were first brought in, to extend the definition to include use for any industrial, commercial or scientific equipment, and also expanding the term process. Now, in that, the facts of the case were that a end-to-end connectivity was provided by Verizon to a customer in India. Due to regulatory restrictions, it could not provide connectivity between the customer's office premises and a port immediately outside India, and so therefore it had to rely on BSNL to give that leg of the connectivity. The court held that this was not to be looked at two separate contracts, it was a unified contract as a whole. And the court held that this was nothing but payment for use of an equipment, and therefore it was royalty. Not only it was royalty under the Act, but it was also royalty under the India-Singapore Trade Tax Treaty, the article dealing with royalty. Simultaneously, the court also held that it was a payment for a use of a process, and even on that score, explanation to the 916 was brought into play, and the court held that this is actually royalty. Now, startingly, the Madras High Court has just reproduced the definition of royalty under the domestic law and has reproduced the treaty, and then just makes one sweeping observation that both of these are in para material, and therefore it makes no difference so long as it is taxable whether in the Act or in the treaty, both of them are equally taxable. Now,